Hi, I'm Anthony Alder from Alder IP, and welcome to another episode in the IP series. Today we're going to be talking about the New York Times and Wordle. Wordle's a pretty famous game, and the New York Times actually owns Wordle. They bought the game. The problem is that New York Times has now been sending takedown notices or digital takedown notices to people that they think are infringing their game. And New York Times actually believes that the trademarks have been copied, but also believe that the copyright in the game has been copied. Now, the problem with that statement is the fact that you don't really have much of a copyright in a game. You don't have copyright in the mechanics of a game because it's industrially applied. The only thing you have copyright in is maybe the layout, the tiles, the colors, the words, the instructions. You have those sort of things. As for actual game mechanics, you don't have any kind of protection. The New York Times went after a gentleman who published a program on GitHub, and that program referenced that it was a Wordle clone, that it was a copy of the Wordle game. The problem with that is when he started to say that it was a copy of the game, he's basically saying it was a knockoff copy. And by his own admission, he's saying that not only has he copied the actual trademark of the game, because he's been using the trademark because he's calling it Wordle, a Wordle clone, that's a trademark infringement, but he's also saying that he knocked off the code. Okay, so in this particular case, it sounds like that he's actually copied the copyright in the code as well as the trademark. But there are an awful lot of Wordle games out there that are not infringing the copyright. And if they don't copy the layout of the game, if they don't copy the overall look and the feel of the game, and they don't copy the source code, I think you're going to really, really struggle to say that they're infringing copyright. However, if they do use the name of the game, even in sort of a loose basis, like saying it's a Wordle clone, then it is a trademark infringement. And they're the other things you have to watch out for. You can use the term Wordle as a comparator. So I could say, for example, in comparative advertising, my game is like Wordle. It's not Wordle, but it's like Wordle. And that'd be fine. But saying it is a Wordle clone or saying it's a knockoff copy of Wordle, you are saying what it is. You're saying it is Wordle. And this is why you got to be very careful about, particularly in advertising, about the terms you use around trademarks. And also, if you're writing software and you are sort of imitating somebody else's software, you got to make sure that you're not infringing their copyright. Don't infringe the overall look and the feel of the output of the software, and also don't copy the source code either. And also try not to circumvent any security measures that are on there. I hope this has been really helpful. I hope this has given you some idea of particularly copyright in the software setting. If you need any more help or information about copyright or how software interplays with copyright and trademarks, please feel free to contact myself or the Alder IP team, and we're more than happy to help you out.